They have to say to their elected officials, we elect you, you work for us.
That's Barbara Bartoletti, the League of Women Voters, after the Sheldon Silver verdicts. Guilty on all 7 counts. And we're joined now by legal analyst Chas Farcher from Martin, Harding & Mazzotti. Hey, Chas.
Good morning, Chuck. How are you?
I'm good. So let's talk about, personally, as someone with no legal background, I thought, man, a conviction might be tough because even though the stuff was sleazy, maybe it wasn't illegal. Were you surprised by the verdicts?
No, I don't think so. I think, we've got a kind of a consensus in our office. There's going to be a guilty verdict coming for Sheldon Silver. I think the feeling is kind of similar on the Skelos trial as well, but I guess time will tell with that one.
Why do you think the Silver case was so clear that he was guilty?
Well, I think, unlike if you compare it to the one you had more recently with Joe Bruno, here there was just a lot more evidence of direct quid pro quo. You had a doctor come and testify. You had lobbyists come and testify that essentially, in terms of the two schemes there with the doctor, I would send him mesothelioma patients, or I would try and direct mesothelioma patients to him, which are very highly coveted personal injury cases worth 7 figures. In exchange, he would direct state grant money to me. Or with the lobbyists, he would come in and talk about how I set up meetings, for a real estate development company, and he in turn, Sheldon Silver would vote favorably on legislation, and then these real estate companies would direct their business to him. So there was a lot more direct evidence of quid pro quo than you had, say, with the prior trial involving Senate Majority Leader Joe Bruno.
See, I thought that as well, but then when I started seeing the notes coming from the jury, I started to think, well, maybe they weren't real convincing. That one woman initially said, I'm not really sure. I feel stressed and pressured and I need to go home. And then the other one said, basically, there's an idiot amongst us and doesn't understand the charges. And then the third one that came out that said, I have a conflict of interest. So I thought, oh, geez. I'm not sure how well they're explaining things to the jury. Maybe they don't understand, or this is going to happen and he's going to walk.
Yeah, and it's always interesting when you get some of those notes from the jury, but you got 12 jurors and you got the 4 alternates. They excused one early on, and so you're right. When you see some of those notes, maybe you get the feeling that, oh, man, they're leaning towards acquittal or something else. But I think maybe what you had there were the 2 or 3 jurors who were kind of the oddballs, so maybe you had 2 or 3 that were leaning the other way with pressure from the entire pool for those people to switch the vote, and that's why they wanted out of the jury pool or the jury panel. But that's part of the deliberation process, and that's how the whole thing works. I think the bigger problem for people like Sheldon Silver and Dean Skelos currently is just the whole atmosphere. You've had, over 30 politicians booted from office in the last decade or so, and it's just a bad atmosphere to be a politician on trial for criminal charges.
So, Kelly mentioned the jurors, and we're speaking to Chas Farcher, our legal analyst from Martin, Harding & Mazzotti. There were a couple of jurors who wanted out, but the judge said get back to work, basically. Is that something that they are going to appeal the case? Is that something that they might try to throw against the wall in an appeal?
Yeah, I think absolutely. When you appeal to the Second Circuit or when you appeal any criminal conviction, your chances of success are generally less than 1 in 10. It's usually about 8% on a state level. So 92 out of 100 times you're going to lose. So when you file that appeal, I think you got to preserve every issue. I think you got to appeal any issue that a panel of judges might have a hope of latching onto, and maybe they can say, well, hey, look, you had several jurors here who indicated that they couldn't be impartial or had problems with the cases. But a lot of that's a discretionary issue that's up to the judge. Can the jurors still reach an impartial conclusion? Can they still participate in the deliberation process and be fair about it? And if the answer is yes, then whether the fact that they want off a jury panel is, it's irrelevant. I think everybody wants off a jury panel. But,
yeah.
It's got to be done.
Do you see any? I'm sorry, Kelly. Do you see anything meaty there that might win an appeal beyond the juror issue?
I don't think so. And it's odd because if you look at it again and you compare it to the Bruno case, the thought process. Well, Bruno was convicted. There were 8 charges. He got convicted on 2. He appealed and he won, and he never saw any time in prison, and that's the way it will go for Sheldon Silver. But I think the big difference that you got to realize is that at the time of Joe Bruno's conviction, the Honest Services Law, which is the same law that Sheldon Silver's been convicted under the majority of charges here, was kind of in flux, and there was a pending case with the Supreme Court, and was that law going to be changed or altered? And, he didn't actually necessarily win on his appeal. The Supreme Court changed the law during the course of his case. The law is now in place, and what the law went from was having to show an appearance of impropriety essentially to a quid pro quo, and they couldn't do that in the Bruno case. They've done it here, and I think they'll do it in the Skelos case. So I think Sheldon Silver has a much harder road to travel here in terms of an appeal.
And how long will that process take? I mean, you're talking a guy who's 70 years old, who has a lot of money, who could probably drag it out as long as possible.
Yeah, you're probably looking at 18 months to 2 years before you hear an appeal and have a decision on it. Yes, you're probably talking a couple of years before there's an appellate decision. But again, in the case with Joe Bruno, they were able to delay his sentencing, so he never actually saw any time because the argument was, well, look, this case is being heard by the Supreme Court. The law may or will likely change. Let's not sentence this guy to prison only to have the law change and have to take him back out. Here, the law is in place already, so I don't know that the same argument is available for Sheldon Silver. If I'm the U.S. attorney, there's no reason to delay sentencing at this point. Let's go forward and sentence him. And, like any other criminal, if he appeals and he's 8 out of 100 who win, then good for him, but that'll be 2 years from now.
So we got to let you go, but do you think he might go to jail, actually be behind bars during his appeal?
Yeah, I don't see any reason why not. There's always an argument to be made that there are extenuating circumstances. He's at the end of his life. He's not doing well health-wise. But like you said, in terms of not seeing jail time, I don't think the arguments are there that Joe Bruno was able to avail himself here anymore.
Chas Farcher, our legal analyst from Martin, Harding & Mazzotti. Thanks a lot, Chas.
Have a great day, guys.
You too. Take care.